So my name is Heidi Klippel, and as you just heard, I've been practicing estate planning for almost 20 years. Our firm practices in estate planning, trust administration, probate, and conservatorship, so we know all the different aspects of the estate planning laws. So I'm going to just talk primarily today about probate, what it is, how it works. But in talking about probate, we'll also be talking a little bit about estate planning documents as well, as they are all kind of intertwined. So let me just start off by saying when a person passes away, that is when you have to decide whether or not probate is legally required under state law. All of the states in the United States have their own individual estate planning laws. So what happens in California is often unique to our state. Some of our neighboring states have similar probate laws as our state, but once you get out to the Midwest, into New England, those are separate property states, and so their laws can be rather different. So I do want to just preference this presentation by saying that everything I'm covering today is all California law specific. So everything I'm talking about pertains to estate plans or wills that are drafted under the laws of the state of California. So when a person passes away, there are two things that takes their estate into court. And this often surprises a lot of people. So the first thing that can take an estate into court is when you own real property and it's not titled in a trust, or if you have liquid assets that are in your individual name that do not have a pay on death beneficiary attached to them. So if my husband and I both owned a house and I died, then we avoid probate at my death because there's still a surviving owner. So when there's a surviving owner, you don't have to go through probate. But when my husband passes away, if our house is titled in his individual name, all real property in the state of California that's individually titled and not titled in a trust or that doesn't have a living co-owner attached to it always goes through probate. And that's why so many people, have trusts. So the way you avoid probate when you're a homeowner is you create a trust, which metaphorically I like to say that a trust is like a bucket. So first you meet with an estate planning attorney and you decide the size, shape, and color of your trust bucket. And then once you sign and notarize the trust, that's when the trust exists, and that's when you move all of your assets into the bucket. And by moving assets into the bucket, I'm talking about your liquid assets, taxable assets, checking accounts, savings accounts, money market accounts, CD accounts, and taxable investment accounts. Timeshares should also be titled into the bucket. Real property should be titled into the bucket. The only asset that you have that does not go into the bucket are your retirement assets. So 15 years ago, all of us estate planning attorneys advise clients to name their trust as a beneficiary on their tax deferred assets, which would include your 403B, your IRAs, your 401ks, your SEPs, your simples, your IRAs. But now going forward, laws do change, albeit slowly, but those retirement laws have changed pretty dramatically over the last 10 years. So now we advise clients against naming their trust as a pay on death beneficiary. So for those of you who have an estate plan, if you did your trust 10 years ago or longer, then there is a good possibility that you might have named your trust as a beneficiary on your retirement account. And I would encourage you to log into that, check your beneficiaries. And if you do have your trust named, you do want to change that. So for retirement accounts, you want people as beneficiaries. So usually if you're married, your spouse would be your primary beneficiary 100%. If you have children, then your children would be named individually as your secondary beneficiary equally. And then if you have grandchildren, you could name them third. But you always want individuals or organizations named directly for retirement beneficiary, pay on death beneficiary designations, and not named the trust. So I have a lot of people that call our office that tell us that they have a will and that they're happy with the will and that they don't want a trust because they feel like a trust is complicated and they know that they're going to be fine and that their loved ones won't have to go through probate because they have a will. So I just really want to be clear on this point that in the state of California, if you own a house and if nobody living is tied to that house and you die, having a will does not keep you out of probate. Having a will just tells the probate court who's going to be your executor An executor is the person that has the legal duty of administering your estate, and a will tell the court who the beneficiaries are. So it's really important to understand that in our state, if you own a house and if you have a will, that house will go through probate once all of the owners of the house pass away. But when you have a house and when the house is titled in the name of a trust, then the house avoids going through probate. And I'll just real quickly take a step back and explain there's three problems with probate in the state of California. One problem is it is a public process. So if I died and if my estate went through probate, anybody can pull my file because it's a public document, and they can find out who my beneficiaries are, where my beneficiaries are living, how much money my beneficiaries are inheriting, and they'll also find out my beneficiary's date of birth, social security number, and current address. So for me, that would be my husband first and then my kids. So most of us in today's crazy world of identity theft, the one thing we don't want out there is all this private information. But it's important to explain that whenever your estate goes through probate, all of that personal and confidential information does become part of that public process. And the reason it becomes part of the public process is so that your creditors know who your beneficiaries are, how much money you have, how much debts you owe, so that a creditor can make an educated decision as to whether or not they want to put in a claim against your estate. And that's why those laws are in place. They're older laws, but they're still the laws. So when you create a trust and when you have your assets titled properly at the time of your death, you will avoid probate, and none of that information has to become part of the public file. And that is the goal of having an estate plan. The other thing that's important to mention as far as why probate is not necessarily an ideal experience is, in addition to it being public, it's also a very slow process. So under California law, when we file a petition to open a probate estate, under our state laws, the quickest a probate can be finished is 6 months from the date of that first hearing. So oftentimes, just time-wise, what happens is first I meet with the client, I gather the information, I draft the petition to open the probate, I file the petition. When I file the petition, usually our probate court is backed out about 2 months. So if I file the petition in February, hypothetically, the soonest I'm probably going to have that first hearing is not going to be until March, April. So now I've met with my client, I filed the petition, and by this point in time, probably 2.5 to 3 months has gone by where these assets are idle, and legally nobody can touch these assets until you've had that first probate hearing, because the purpose of the first probate hearing is for the courts to appoint an executor, because the executor is the person who has court legal authority to deal with the assets that are part of that probate process. So until you have that day in court and until the judge makes that decision appointing and recognizing that executor, these assets that are subject to this process are idle and cannot be touched. So once you have that first hearing, now we have an executor, and now the executor's job is to gather all these assets, gather all of the debts, and their job is to protect these assets while the probate is ongoing. So I always let the executor know that if there is a house that's part of the probate, they want to make sure that the house has adequate insurance. You want to make sure that the homeowner's insurance doesn't lapse. You want to make sure that the property taxes are current and paid. You want to make sure that if there's a vehicle, that nobody's driving that vehicle, because if somebody's driving a car and if the car's involved in an accident, now you're going to have litigation against the estate. So if there's a vehicle that somebody owned at the time of their death, you don't want anybody driving that car. You can contact the insurance company and put the car on non-operating status, which will usually take that insurance premium down to 10%. And you want to make sure that somebody is starting the car periodically, because that engine is going to need to be started and run. Once you've been recognized as the executor, you have legal authority to deal with these assets. So during the probate process, if nobody wants the car, the executor has the ability to sell the car. If the will says that a beneficiary is entitled to the car, then they'll get that car title at the end of the probate process. The executor also has to do what's called an accounting. So early on, in the probate process, the executor prepares a document called a preliminary and first accounting. And the purpose of that document is to show the court all of the assets of the decedent and all of the debts of the decedent. And sometimes those numbers are estimated because the executor might not have had an opportunity to meet with the decedent's CPA. And then as you go through this probate process, the executor's job is primarily to pay all of the debts of the decedent, because legally nobody can inherit the assets until all of the debts have been paid. So during this probate process, the executor is going to be meeting with the CPA, preparing that final state and federal income tax return, asking the CPA to audit the decedent's social security number to make sure that all of their past tax returns have been paid and are current. Every once in a while, you might have somebody who is exempt from filing a tax return if their assets aren't significant enough where they have to file those tax returns. But legally, it is the executor's job to be talking to a CPA to make sure that the state and federal tax returns are all current and paid. And sometimes the executor will sell real property during this probate process. If nobody wants to inherit the property, the executor does have the ability to change the form of the asset, so the asset can be sold. A notice is filed with the court. It's called a notice of proposed action, where the executor notifies the court that the real property is going to be sold. The beneficiaries are also notified that the property is going to be sold. That gives the beneficiaries the opportunity to make any objections. Normally there aren't any. And then the executor does what's called a final accounting. So towards the end of this 6-month period, the executor then prepares a final accounting, and that's basically where the executor has done all of their due diligence and they're showing the court the final documentation as to the financial assets and status of the decedent's estate. The purpose of the final accounting is to show the courts all the debts that have been paid, that the taxes have been paid. If any income has come into the estate, the executor also shows that. And then I get to the third point as to why probate is not the most desirable process in the state of California, and that has to do with the executor's fees. So under California law, when you have a probate, the fee that is due to the executor and to their attorney is decided by law. It's not a fee that's negotiated, but it's a fee that's based on a percentage calculation of the value of the assets that are going through the probate process. At a minimum, a probate in the state of California is going to cost $15,000, but oftentimes we see probate fees that are closer to $25,000 and $50,000. And the reason those fees are so high is because the executor is entitled to the fee, their attorney is also entitled to the same fee, and then you have around $1,500 of filing fees, publication costs, and court order fees. So all in all, if you have an estate that's going through probate, if the estate is worth around $150,000, those probate fees are going to be around $15,000. The higher the value of the assets, the higher those statutory fees are, because the attorney and executor get paid a percentage of that gross value of those assets. So because real property not titled in a trust always triggers probate, you want to always make sure that when you have a trust that you've put the house into the trust. And a common mistake that happens, which really isn't anybody's fault, is once the house goes into the trust, when interest rates go low, which they recently have, people will often refinance to take advantage of these lower interest rates. Some mortgage companies, not all and not as many now as they used to about 10 years ago, during that refinance process, they'll take the house out of the trust. Unbeknownst to the client, the house is coming out of the trust for that refinance process. So unless you tell the mortgage company in the escrow paperwork to make sure that the house goes back into the trust at the close of the escrow process, it's not uncommon when a house is refinanced that it started off in the trust, but once the refi is said and done, the house is now outside of the trust. And if somebody doesn't make that discovery, now you have somebody with a trust, but if the house is not titled in the trust, we're still going to have a probate, because in California, it's the title of the assets that determine whether or not we have to go through the probate court. So in my hypothetical, when people call me and they say, Heidi, I have a will, I have a house, but I have everything in order. The will's done, it's done well. That's not what determines whether or not we go through probate. If you have real property, having a will does not keep you out of probate. It's putting that house into a trust that's going to keep you out of probate. So one recommendation I have is for those of you that have taken advantage of these interest rates, it would be a good idea for you to check the title of your house just to make sure that if you refinanced, that at the close of that refinance, the house went back into the name of the trust. And if it's a California property, we can check title. It's free to us. If you want to send me an email, I'd be happy to check title for you. If you want to check your property tax statement, that's a good place of checking, because usually how the property tax statement is addressed will show whether it's in the name of the trust or whether it's in your names as trustee of your trust. If it's just in your individual name without any reference to trustees or a trust, then chances are your house is no longer in the trust. So that means you're going to want to prepare a new deed to put the house back into the trust. So those are the three problems with probate in California. Just to recap, one problem is probate is a public process. So everything about your loved ones is public. Their names, their addresses, their social security numbers, dates of birth, how much money they're inheriting, all of your debt, all of that's part of the public process. And that's to protect the creditors. The other problem with probate is at a minimum, a probate has to be open for a minimum of 6 months. But oftentimes, by the time you file the petition, get the first hearing date, get the second hearing date, and possibly get your third hearing date, most oftentimes, because of the court's very compacted calendar, most probates usually take about a year from start to finish, which means those assets are under the court's jurisdiction for that full year's time. During that period, once an executor has been recognized as being the person who's in charge of these assets, at that point in time, an executor does have legal authority to change the form of an asset. So if nobody wants the house during the probate process, the executor can sell the house, and then those monies will go into an account that's overseen by the court. And at the conclusion of the court process, those monies will be distributed to the beneficiaries. And then the third problem with probate are the fees. So one really big problem is our fees are based on a percentage calculation of the gross value of the assets that are before the court. So anytime you have a house that's going through probate, you're looking at probably around $15,000 to $25,000 in fees. The great thing about California is you can avoid probate by having a trust, and as long as these assets are titled properly, by avoiding probate, you avoid paying all of these unnecessary fees, which means not only will your loved ones get more of your assets, but you've also protected your loved ones by keeping all of their information private. So we've talked about the three reasons why probate's bad. The one thing I do want to go back and talk a little more about is the two things that take us into probate. So I think I've done a pretty good job explaining that real property that's not titled in the trust will always trigger probate when there's no living owner tied to that property. The other thing that triggers probate is each state, and all states are different, they'll give you a bucket of assets that if those assets aren't titled in a trust, or if they're not jointly owned, or if there's not a living pay on death beneficiary tied to those assets, if you took those assets and added them together, and if their total aggregate value exceeded $166,250, then those assets would trigger probate. So an example of this is if I died yesterday, to not jinx anything, if my car was not titled in my trust, and if I had a bank account that was not titled in my trust, and if the bank account didn't name any beneficiaries, if you took the value of those two assets and when you add them together, if it's over $166,250, then those assets would trigger probate. But if I have a house and if I have a trust, and if my house is titled in the name of my trust, then the house does not have to go through probate. Only the assets that are in my name that don't have a beneficiary tied to it that exceed the $166,250, those assets only would go through probate. And that's a good thing, because by my house avoiding probate, the fees of probate are going to be a lot less, right? So that's really important to understand. So when we do an estate plan for clients, part of what we do at the end of the process is we give clients something that we call homework. And part of the homework is I can prepare a deed and I can put my client's house into the trust, but I can't put their bank accounts into their trust, and I can't update their life insurance beneficiaries to have the trust as the beneficiary. So clients have to do that on their own. And that's for your protection, because that would be a pretty scary world if I could just walk into a bank and change the assets and how they're titled. I'm just going to go to the chat real quickly. Sorry, 1 second, because there's a question. It says, "Hi, Heidi, you did our trust and I tried to get my mother-in-law to do one, but she refused. And she passed recently and had a trust, which named me as her personal representative." 1 second, sorry. I did not, okay. So I'm just going through this. 1 second, I'm sorry. So when a person dies, if they have a house that's not titled in a trust, then it will have to go through probate. And if they have an account with a POD or a TOD, which that stands for pay on death and transfer on death, as long as the beneficiaries tied to those accounts are living, then the bank will release those assets to those beneficiaries 40 days after the date of death of the decedent. So that's another good point to mention about probate, is that if you have a person, a loved one who dies, and if they do have an account in their individual name, regardless if there's a beneficiary tied to that account or not, under California state law, those assets will be frozen for a minimum of 40 days. So if there is a TOD or POD, which means pay on death beneficiary associated to those accounts, the executor would notify the bank by showing them an original certified death certificate that a person has passed. And then the bank would have the beneficiary's information on file, and the bank would go ahead and notify those beneficiaries and would release those funds directly to those beneficiaries. It's important to note that IRAs and annuities are treated the same way as bank accounts. So those assets are also frozen for 40 days. And then after the 40 days have passed, the IRA institution, 403B institution, the annuity institution would then contact the beneficiaries once the executor has provided the original certified death certificate, and then the financial institution would contact the beneficiaries, and then the beneficiaries would fill out a claim form, and the financial institution would release those assets directly to the beneficiaries. So then I'm just going to the next part of this question, where it says, "She added my brother-in-law to the house by a deed. The house was spelled out in the will as going to him as part of his 50%. So I think one thing I'd need to know about this question is, when you say that she added your brother-in-law to the deed, there's two ways of owning real property with individuals in California. One is to own that property as joint tenants with rights of survivorship. So if I and my sister were joint tenants with rights of survivorship, and if I died first, the significance of real property ownership in that method is that whoever survives owns the property 100%. So as far as the house goes, we'd have to look at the deed to see if it's a tenancy in common or joint tenants with rights of survivorship. Because if they were tenants in common, when one person dies, their interest would have to go through probate if their interest wasn't titled in a trust. But if the ownership was joint tenants with rights of survivorship, then the asset doesn't go through probate, but that's because the surviving joint owner would own that asset 100%. And then the next question is, there's a document called a small estate affidavit. So when a person passes away, if you don't have an estate that's probatable, and let's say you have a car and it's in the individual's name, there's a document called a small estate affidavit where the executor is basically stating under penalty of perjury that this estate is not big enough to trigger probate. And once 40 days have passed, that's when the executor can use a small estate affidavit to deal with that asset. So sometimes when a person dies, if there is no house, and if there aren't assets that don't have beneficiaries tied to them that exceed the $166,250, then you would use a small estate affidavit form to deal with assets, to have the executor have the ability to access that asset and to put that asset into the rightful beneficiary's name. Now, sometimes the beneficiaries don't always want that asset, and that is when the executor would have the ability to sell the asset and make the distributions to the beneficiaries. So, and as far as insurance, oh, okay, so now you're saying the deed was right of survivorship. So right of survivorship basically means that when your loved one dies, your brother-in-law owns that property outright, so it wouldn't go through probate. And then your last question, which is a great question, is when is insurance paid to beneficiaries? So when you have an insurance policy, generally life insurance policy, you can name who the beneficiaries are. And again, an executor would be under a legal duty to notify the life insurance company that a loved one has died. And then after the 40 days has passed and after the executor has given the life insurance company an original certified death certificate, then the life insurance company would contact the beneficiaries that are on file, and they would go ahead and release those assets to the rightful beneficiaries. So basically, when a person dies and they don't have a trust, the executor's primary job is to locate the assets, to locate the debts, to figure out whether or not a probate is required. If a probate is required, they're going to hire usually an attorney, because that's a pretty significant process to do on your own. And you file the petition to open the probate. That's when the executor gets recognized by the court. That's when the executor has the authority to deal with the assets. Want to make sure that they have the proper insurance on those assets. Then the executor is going to do that preliminary accounting to show the court the assets and debts in the estate. Then the executor does all the due diligence of the estate of paying those debts. And then the executor files that final accounting to show the court the financial status of the estate. All of this information is also given to the beneficiaries. The beneficiaries have a right to hire their own attorney. The beneficiaries have a right to ask the executor questions. And then once the court approves that final accounting, that is when the executor can make final distributions. And then once all the distributions have been made, that's when the executor's job is done. So another question here, which these are great questions, is there a 40-day wait for joint bank accounts? And the answer to that is no. So when a person has a joint asset with another person, if one person dies, there's no probate because the surviving owner will own that account outright. Okay, so now you're asking me a question about Georgia. So unfortunately, I can't answer questions about Georgia because I'm not licensed there, so I don't know how their laws work. So unfortunately, you're going to need to contact an attorney in Georgia and have them talk you through any questions you have about their processes. If you have that ARAG legal insurance, ARAG luckily is a national legal insurance. So oftentimes people that live in California can go through ARAG and find an out-of-state attorney that's covered through your ARAG. So Sam, I would encourage you, if you don't mind, to call ARAG if you have it. Ask them to put you in touch with an attorney in Georgia that preferably lives in the county where your loved one passed. And they should be able to answer your question about the 40-day hold and all of that. Because unfortunately, like I said, states have different rules and laws, and I only know California. Somebody did ask me to put my email address in the chat, so I'm going to put my email here. Like I said, if any of you have trusts and if you've refinanced, if you want me to check title, it's free to me, so it's free to you. I'd be happy to check title of your house to make sure that it's still correctly titled. I also put our office phone number there. And now I'm going to let you know that we are also part of ARAG insurance. So if you do have that insurance coverage, we do accept that. If you don't have that insurance coverage, I'm pretty sure that ARAG has open enrollment in November. So you might want to put it on your calendar to look into that. The way ARAG works is basically if you have assets in another state or county, just California. So that's a good question too. So basically, when you create an estate plan, like my estate plan is written under the laws of the state of California, but in California, well, most states for that matter, you can take assets in other states and put them into a California trust. So I could have a California trust and have a house in California titled in that trust. And I could have a house in Hawaii titled in the name of my California trust. But when you have an estate plan, the documents itself will identify the laws that apply to those documents. but you can have assets under a California estate plan that are located in different states, but the laws of the state of California would apply. So if a person lived in Texas, for example, and if they had an estate plan under the laws of the state of Texas, but let's say that a house was located in California, that California asset is under the rules of the Texas estate plan, even though the asset is located in the state of California. So one nice thing about an estate plan is these estate plans are recognized in all the states, but the laws that apply to that estate plan are the ones that are applicable. So for example, we can help clients administer an estate if the estate plan is written under the laws of California, even if some of those assets might be located in other states. But sometimes we had a client once, sadly, that she bought a whole bunch of property in New England. And for whatever reason, when she bought those assets, she didn't put them into her California trust. And those assets had to go through probate in the state of Massachusetts. But because we're not licensed in the state of Massachusetts, she ended up needing 2 attorneys involved in that trust administration, because we were able to administer the laws of the state of California and deal with the assets here. But an attorney in Massachusetts had to be hired because we don't know the laws of Massachusetts, so we couldn't open that probate. So that attorney opened the probate in Massachusetts, and we told them how the laws worked here. So I will tell you that when you do an estate plan, once you create an estate plan, you're not done. So it's really important to make sure that you're always titling your assets the right way, because having a trust doesn't keep us out of probate. As I mentioned earlier, you want to think of a trust like a bucket. So if I went to an attorney and if I created a trust, I have to put those assets into the name of the trust for the trust to have control over those assets. So if I created a trust and if I didn't change the title of my house, so my house is titled in the trust, because the trust is outside of the trust, it's going to go through probate. But when you have a trust, you have a special kind of a will called a pour over will. And it's in a will that you nominate an executor. An executor is the person who deals with the probate. A trustee is the person who deals with the assets titled in the trust. When you create an estate plan, there's 3 financial documents that you're creating. One is a trust, one is a durable power of attorney for financial affairs, and the third is a will. You also have a healthcare directive, but the healthcare directive, you can name whoever you want to make medical decisions, but logically, when you pass away, the healthcare directive passes away with you. But in the other 3 documents, your 3 financial documents, the trust, the will, the durable power of attorney, you're always going to have the same people in the same order listed on those 3 separate documents. So whoever's named as your trustee is also going to be the person who's named as your executor, who's also going to be named as the person who's your durable power of attorney. So you always want the same person throughout those documents, because assets titled in a trustee has control over. Assets that aren't titled in the trust, if you were alive but incapacitated, your durable power of attorney gives control over. But when you die, your durable power of attorney dies with you, so that when you pass away, any asset that's titled in your individual name, that's when the will comes in and the executor has power over assets that aren't titled in the name of the trust. So I know that's a lot that I just said, but there's a lot of moving parts in estate planning. So since we are talking about probate, I'm not trying to spend too much time talking about trust and durable powers of attorney, but I do think it's important to understand how all of these assets work, so that that way you know all the moving parts. And for those of you that are putting questions on the chat room that are very personal and specific, if you want to just send me an email with those questions, that would probably be a better use of everybody's time versus me spending time giving specific legal advice about a personal situation, if you don't mind. But just to go back one more time, in case if I did it too quickly, that's a great question. I do have a handout that I would be happy to email to all of you. I just didn't have everybody's email address. So what I'll do is I'll send the email to Vanya with the handout, and then she can forward it to all of you. I do apologize, as I was out of town last week. There was a miscommunication with scheduling this presentation, but I do have a handout that talks about probate, the roles of an executor, and it also gives some examples about probate fees and how enormous they can be. So I'll send that handout I'll email it to Vanya. She can email it to all of you. And if any of you have any questions, you're more than welcome to email me. But just to go back about the small estate affidavit, what happens is, you're welcome, is when I die, if I have a trust and if my house is titled in my trust, which is how you want it, and if I have my bank accounts and my checking accounts titled in my trust, which is how you also want it, and if I have my retirement accounts not giving to my trust, but to people, and they survive me, then those assets go there. And now let's say I have a car. So I pass away, my house is in the trust, my bank account's in the trust, my investment account's in the trust, my life insurance names the trust as my pay on death beneficiary, my retirement accounts name my husband first and my kids second as the pay on death beneficiary. But I have this one asset that's in my name, a car, that doesn't have a beneficiary tied to it. How do you deal with that? That's where a small estate affidavit comes in. So in California, when a person dies, one of the first things that an executor or trustee has to figure out is, do we have assets that would trigger probate? If you have assets that trigger probate, you can't deal or touch those assets until the court has recognized and appointed an executor. If you don't have assets that trigger probate, in my example, I gave a car. So let's say I have a car that's worth $35,000 and that's the only asset that's in my name. Because California gives me a window of up to $166,250 and this car doesn't trigger that, we don't have to go through probate. But now nobody's going to want to deal with me because I have an asset in my own name until they know that there's no probate needed. And that's what a small estate affidavit does. The purpose of a small estate affidavit is when a person dies and we don't have to go through probate, the executor signs this legal document under penalty of perjury, stating that there's no probate needed. But that asset is under that 40-day frozen period because it's an asset that's in my individual name. So when I die, if my car is titled in just my name, my husband can't put that car into his name or sell that car until 40 days have passed from the date of my death. And then he would utilize a legal document called a small estate affidavit, where he's stating under penalty of perjury that there is no probate. And that's how he would be able to change the title of the vehicle out of my name because I died and into his name or into our kid's name, or if he was gifting it or donating it or selling it. So in California, when you have an asset in a person's individual name, there's two ways that financial institutions are going to deal with you. They're either going to want letters testamentary. Letters testamentary is the legal document that the court issues in a probate when they've recognized an executor. And that's when a financial institution will allow you to access a decedent's bank accounts because you've just shown them these letters that the court gave you, which is legally a court order that gives you the court's legal permission to deal with those assets. The other situation is a small estate affidavit when we're not required to go through probate, but you still have to provide some kind of proof that you have the legal ability to deal with the asset. So when a person dies, if we're going through probate, you're going to get letters testamentary issued by the court after that first hearing when the court has recognized an executor. If we don't have to go through probate, which is always better because you really don't want to have to go through probate unless absolutely necessary, then you get the small estate affidavit. But remember, when I pass away, any asset that's titled in my individual name, it's frozen for 40 days. But if I passed away and if my husband and I co-owned a bank account together, that account's not frozen because he's still alive. So when I die, whatever monies are in that joint bank account now belong 100% to my husband. And then when he dies, let's hope that he is named our trust as the pay on death beneficiary. So whatever monies are left in that account don't have to go through probate. They'll go into that trust bucket and they'll go on to our beneficiaries. So again, it's really, really important when you have an estate plan to make sure that you've titled your assets properly, because in California, having a will does not keep us out of probate. Having a trust does not keep us out of probate. It's making sure that your house is titled in your trust that keeps us out of probate. It's making sure that your bank account is titled in the name of the trust that keeps us out of probate. Or if your account is a joint account between you and your spouse, You want the trust named as a pay on death beneficiary, because as long as the trust owns an account, or as long as the trust is the named beneficiary of an account, those assets will never go through probate. Cars don't normally have to go into a trust, because as long as the total aggregate value of those vehicles is under the $166,250, it's not legally necessary to put a car into a trust. But if you're the type of person who collects valuable cars, collectors that will likely hold its value and not depreciate in value, sometimes it does make sense to put a collector's car, classic car, into the name of the trust so it does not trigger probate. If you have AAA, going through AAA is the easiest way of changing the pink slip and putting that asset into the trust. But one quick side note that really has nothing to do with probate, but I think it's important to mention: a lot of times people mistakenly believe that when they put their assets into the trust, they've given that asset creditor protection. But because your trust is revocable, which means it's amendable, which means it's changeable, which is how you want it to be, because life changes, you're going to want to change trustees. Sometimes, sadly, you need to change beneficiaries. Because that trust is revocable, it works like a pass-through entity. So if somebody sadly had any kind of a creditor claim against you, they can reach those assets. So a question that was just asked was about a pour-over will. When you have a trust, you have a special kind of a will called a pour-over will. What a pour-over will says is when you pass away, if there is an asset that's titled in your individual name, you want that asset to go into the name of the trust. So if I died and if I had a car in my individual name, my pour-over will directs that asset to go into the trust, and my trust has my husband as my primary beneficiary. So if I died yesterday, and if my husband wanted to put that car into his name, the pour-over will is the asset that would give him legal permission to have that asset go into his name, because he is the beneficiary of our trust. So when you have a trust, you have a special will called a pour-over will. If you don't have a trust, then you have what's called a testamentary will. So a testamentary will is your good old-fashioned type of will that says who gets the couch, who gets the dog, who gets the car, who gets the money. And that is legally significant in California as long as you don't own a house and as long as your net worth is under $166,250. So whenever you have a trust, you have a pour-over will, and whoever you've named as trustees, those are the same people that should be listed as executors of your will, because you want the same person in charge of assets that are titled in the name of the trust and assets that aren't titled in the trust. And that's why you want those assets to, or the people to match. It's important to mention that when you have a pour-over will, you don't avoid probate. So if I died and if I have a pour-over will, but my house was refinanced and now it's not in the name of my trust, having a house that's not titled in a trust will still go through probate, even if I have a will, even if I have a pour-over will. But the benefit of the pour-over will is now I'm telling the courts that I want that house to be titled into the name of my trust at the conclusion of the probate. So that's a really good question. When you have a pour-over will or any kind of a will, you don't avoid probate if you have a house that's not titled in a trust, or if you have assets that exceed the $166,250. Those assets will still go through probate. The only nuance is a pour-over will have those assets going into the trust. A pour-over will is better than a testamentary trust, because you have a pour-over will and those assets are going into a trust and not to a person. The names, social security numbers, and all that private information is not made part of that public process. So if you had the choice to have a testamentary will or a pour-over will is always better, because the beneficiary of the pour-over will is a legal entity called a trust. So therefore, if you had to go through probate with a pour-over will, nothing about your loved ones becomes part of that public record. And a pour-over will is a special kind of a will that's used when you have a trust. So when I have a trust, a will, you always have a will in California, regardless if you have a trust or not. If you have a trust, you have a will kind of pour-over will. The pour-over will says any asset that's titled in your individual name is going to go into your trust. That's the pour-over clause. It pours over into the trust. But if you have assets that aren't in a trust, that need to go through probate. Even with the pour-over will, those assets are still going to go through probate before they find their way into the trust. If you don't have a trust, let's say I have a client who comes to me, she's 30 years old, she doesn't own a house, she doesn't have over $166,250 worth of assets, and all she wants is a will, then I would do a will for her. But when she died, if her assets were over the $166,250, then those assets would be required to go through probate. So the one thing that I'm repeating a lot, which I hope you could just bear with me, is I just really want to try to hit home that in California, having a will is often not enough. If you own a house, you need to have a trust, and you need to have your house titled in the trust at the time of your death. If you own over $166,250 worth of assets, having a will is not enough because you need those assets titled in a trust. It's also beneficial when you have a trust when you have younger beneficiaries. So in California, if I died yesterday and if all I had was a will, under California law, my kids would get all of their inheritance as long as they're 18 years of age or older. Well, I have two kids, and one is 15 and one is 14. So if I didn't have a trust, if all I had was a will, when each of my kids turns 18, they get all of their inheritance. And by all of their inheritance, I'm not trying to infer that it's so much, but the point being is it's often not a good idea for super young individuals to inherit this money because statistically that money is spent within a 2-year period. And there again, that's another benefit of having a trust. When you have a trust, you can put age contingencies in place. In our trust, we said that our kids get 10% of their inheritance when they turn 25 or graduate from college, whichever occurs first. Just a little bit of money. So if they're not so financially astute with that first distribution, it's only 10% of their inheritance. It's not all of it. And it's not given to them at 18 like the courts would give it to them. It's given at college graduation, which could be at 21 or 22 or 25, whichever occurs first. And we just dangled a carrot for these kids to go to college, because if they go to college, not only is the trust going to pay the tuition, living expenses, and book costs, but they'll graduate at 21 or 22, and that's when they'll get that first distribution. Not all kids want to go to college, and that's okay. So for those that don't want to go to college, they just get their monies a little later, and that's not meant to be punitive. We were just trying to dangle a carrot that we wanted to give an incentive for them to go to college. And then we said that when our kids turn 30, we'd give them a third of their inheritance, thinking that age 30, they're probably getting married, having a family, buying a house. So we wanted to give them a little more. Now, some clients will give half of the monies at age 30. Some clients give all of the money. But we had our final distribution being paid at age 35 because we just figured if for whatever reason at the first and second distribution, if they didn't make the best financial decisions, hopefully with that final distribution, that's the one that they're going to be the most prudent and really save. So the other benefit of having this trust is if you do have younger children, loved ones, nieces, nephews, grandchildren, whatever the case may be, you can put contingencies in a trust that you can't put in place with a will. So if you sadly had a loved one with a drug addiction, for example, you can't put limits in a will as far as drug testing and postponing distributions, because in our state, when you have a will or don't have a will, these courts do not get involved with the administration and oversight of monies for the benefit of a beneficiary. The courts aren't going to get involved and require drug tests. But what the courts will do is once the beneficiary is 18, they'll release from that blocked court account that beneficiary share. But when you have a trust, you're able, because you have a trustee in place, you can put contingencies in place for the beneficiary. So we've got a drug testing clause in our trust. So sadly, if any of our beneficiaries are having issues with illegal drugs, if we were alive, the last thing we do is give them a whole bunch of cash money. But we would want to help pay for their rehab if they were willing to go. So we wanted to give our trustee that same ability. And in our trust, we said the age contingency. So we avoid an outright distribution at the young age of 18. We also said that if any of our beneficiaries are married in our trust at the time of inheritance, we wanted those married beneficiaries to keep their assets, their sole and separate property. So if they later got a divorce, the monies they inherited aren't part of that divorce. So there's a lot of contingencies you can put in a trust. With a will, you can't put any contingencies. We've even got a pet clause in our trust because we want to make sure that if we passed away If our guardian is willing, we're hoping that our guardian will keep our kids and pets together in the same home if possible. And if not, our trustee has our legal permission to find those pets a home or to place them for adoption with a no-kill animal shelter, because we don't want them to be euthanized just because we passed away. So I've done trusts for turtles because turtles tend to live over 100 years. I've done trusts for parrots. Those are called honorary trusts when you do trusts specifically for animals that are likely going to outlive their owners. So there's a lot that you can do with estate planning, but since our focus today is on probate, I just really want to be clear as to what probate is, what triggers probate, and what the bad sides of probate are. On a positive side, the one thing that's sometimes nice about probate, so I can quid pro quo this, is if you have a family situation where maybe you have some pretty contentious family dynamics or litigious beneficiaries, sometimes going through probate can be a blessing. I know that when, I won't say who, but I had a certain family member that died, and a certain family member asked me to be their attorney, and I said I would only help them if we brought the estate through the probate courts, which legally we were not required to do. But I wanted to bring this estate through the probate court because I wanted the judge to sign off and give me their blessing on every decision that we made to protect me as the attorney and to protect my client, my family member, in their capacity as the trustee and executor. So yes, it cost a little more money because there were probate fees that wouldn't have had to been paid, but sometimes bringing contentious matters through the court system is a blessing for the person who's in charge, because by bringing everything before the court, you're giving everybody proper notification. The judge allows the beneficiaries to ask questions. If beneficiaries don't ask questions, or if they don't bring things timely, then the judge will ensure that whatever problems they try to bring up later aren't heard. So the nice thing about sometimes utilizing the courts is you can have the judge be in charge of making sure everything's going according to the law, so that way it's not you telling the beneficiaries how things go. It's going to be the court and the judge being the one delivering all the news, so that way sometimes when people take things personal, it takes the personal out of it, because you have a neutral arbitrator at the helm of the ship, not a family member, not an attorney. And so that's where sometimes having the courts involved can be helpful. I honestly was really surprised when Michael Jackson passed away and he didn't have all of his assets properly titled. And then it dawned on me that he probably did that by design, because maybe he wanted his estate to go through the probate courts, and maybe he wanted that judge involved for all the reasons that I just explained. So I do hope that this is helpful as far as explaining what probate is and how you get there, and that a will does not keep you out of probate. I will say that sometimes people will try to avoid doing an estate plan by having joint ownership, but that's risky. So if you don't mind me just talking about that for a minute. I had a lady call me one time and she says, I'm single. I have one child. She's the apple of my eye. I love her. I trust her. I don't want to do a trust because I think a trust is too fancy for what I need. So what I'm going to do is I'm going to put my daughter on all of my bank accounts as a joint owner, because I know that if we're joint tenants with rights of survivorship, when I die, she'll inherit those assets. So she said, basically, tell me I'm right and I don't need a trust. And I said, well, you're right and you're wrong. I said, you're right in that if you died first, because you're joint tenants with rights of survivorship and there's a surviving owner attached to those assets would not be subject to probate because they're still a living owner. But here's the problem with what you're suggesting. I said, is your daughter married? And she said, yes. I said, do you like your daughter's spouse? She said, not so much. I said, so when you add your daughter onto title of your real property, she's a co-owner. So if her and her spouse got a divorce, California is a community property state. That former in-law of yours is going to basically take 25% of the value of your house as part of their divorce because you added your daughter to title. So co-owning assets with a loved one to avoid probate, not the best idea, because if they get a divorce, some of your assets will be part of that divorce because you co-own that asset on paper, which means what's yours is theirs. The other downside is I had a client who we did her trust. She had a bank account with $200,000 in it. And she told me during our meeting, I have a bank account, I have almost $200,000 in it, and I'm not going to change how that account is titled. She had one adult child. And I said, that's fine. You can keep that bank account in your name, but just know when you die, it's going to be frozen for 40 days because it's an account that's individually owned by you. And you're going to want to make sure that you name the trust as the pay on death beneficiary so that when you die, that account doesn't go through probate. And she says, you know what, though? I don't even want to add a beneficiary. I don't want to do anything with this account. I just want to leave the account the way it is. And I said, well, then you better spend about $30,000 of that account now, because if you passed away, that account's going to go through probate. I said, you should either name the trust, preferably as the beneficiary, because it has multiple beneficiaries tied to it. But if you'd rather just name your daughter, that would be my second recommendation. But my first recommendation is always to name the trust. And she says, you know what? I'll spend it before I die. And sadly, her daughter called a couple months later. Her mom unexpectedly had a heart attack. The account was then worth over $200,000. And because mom didn't put that account into the name of the trust, it triggered probate. And I think the probate fee on that asset was around $22,000. So had mom just put the trust as a paying on death beneficiary, that money after 40 days of her death would have gone into the trust, and daughter would have had $22,000 more in that account. So that whole not putting assets into the trust is not ideal. The other thing that happened is I had another client. She had a bank account. She went to the bank, and the person at the bank said, it's easier if you don't put the account into the trust, but just add your daughter onto title. And so she called me from the bank and said, this is what I'm being told. I said, well, that's not what you want to do. You want the account either in the name of the trust, or you want the trust as the beneficiary. Because if you put your daughter on title as a co-owner, she co-owns that asset. So if she has any kind of negligence, creditors, liability, your assets are reachable by her creditors. If she was having a bad day or had a gambling problem that you didn't know about, she could take all of the monies out of that bank account, and legally there's nothing you can do. So I didn't hear from her for a couple of months. And then sadly, one day a call came, the receptionist came in. She says, Heidi, there's somebody on the phone. She's crying hysterically. I don't even know what she's saying. Can you please take this call? So I got on the phone. It was that same client. She decided to do what the banker was recommending and do what was easy. She named her daughter as a co-owner on her checking account. Unbeknownst to her, her daughter had some back taxes that she hadn't paid. When the IRS audited her daughter's social security number, they found that daughter was a co-owner of a bank account, and they pulled out $97,000 out of this bank account. So she calls me saying, I need your help. I need you to help me get that money back. And then I got to be the bad guy to tell her, I'm so sorry, but legally, once you added your daughter as a co-owner, her liability is your liability. So whether the daughter's getting a divorce, whether the daughter's having a bankruptcy, a gambling problem, an IRS back taxes problem, whether she's in a car accident and it's her fault and she's underinsured, you don't want to co-own your assets with people, because now you're opening up your assets to being liened by that individual's creditors. So another benefit of having assets in a trust is there's language in a trust that says if you lost capacity, your trustee could come in and manage your assets for you. But they're a manager, not an owner. So if they had a car accident, or if they filed bankruptcy, or if they had back tax problems, their creditors can't come after your assets. And it's also important to note that when you create a trust and you name somebody to be a trustee, because their job is a manager, they're not ever personally liable for your expenses. Because I've had people call and ask me that. My mom wants me to be her durable power of attorney, or my mom wants me to be her trustee, but I'm afraid that I'm going to have to pay for your mom's debts. When you come on as a person's executor of a will, or as a durable power of attorney, or a trustee of a trust, you are managing those assets on behalf of a loved one, which means you have no personal liability for their debts. Mind you, if you mismanage their monies, then you might have some personal liability. But one thing that's important to mention is when you are acting on a loved one's behalf in a fiduciary capacity, some assisted living facilities now have language in their contracts where they might ask you to sign a contract when you're basically having a loved one come into an assisted living facility. Oftentimes, if you're asked to sign a contract, there's language buried within the terms of the contract where you're agreeing to be a personal guarantor, so that if that person's assets are less than what monies are owed, you're voluntarily agreeing to pay whatever balance remains. So just know that whenever you're acting in a capacity as a durable power of attorney, a trustee, or an executor, whenever you're asked to sign off on a contract that's really for a third party and not for your personal, if you're asked to sign off on that, you really want to make sure that you're reading that contract or have an attorney read the contract, because often buried in all the legal jargon is that personal guarantee language, but you don't have to sign off on, and you shouldn't, frankly. And if that means that that assisted living facility won't take your loved one, then I can tell you there's 10 more that will. So being in the know and asking questions is really important. I really am so happy that all of you took the time today to listen to this presentation, because knowledge is power. And like I said, I will send the handout to Vanya. I'm so sorry that I didn't get it to her before this presentation, but I'll send it to her. My name, my email, my phone number is on that handout. If you have any questions, I know there were a couple of questions that were more personal in nature. If you'd like to send me those questions, I'm more than happy to answer them. I just thought it might be better to do that with you directly one-on-one versus through this presentation forum. And like I said, for any of you who have ARAG, they do cover estate planning as part of that legal insurance. So if you have an estate plan, I would encourage you to utilize your insurance. Part of what that insurance covers is a review of your estate plan. You do want to make sure that you're reviewing your estate plan about every 8 to 10 years, because the legal language does become stale, for lack of a better word. So the laws change, especially the tax laws. I mean, 10 years ago, we used to say name the trust as a beneficiary on your retirement accounts. Now we don't recommend that. So just know that an estate plan is kind of like a car, right? It does need to be tuned up and reviewed. Sometimes people come in here thinking they're going to do an estate plan once, throw it on the shelf, and it's good forever. That's not true. You want to make sure that you update the legal language about every 8 to 10 years, bring it current to today's laws. When you review those documents to bring that language current, that's a great opportunity to look at who you've named as your executor, trustee, durable power of attorney. Sometimes people's capacity and health change, so that might necessitate wanting to change who those individuals are. As your kids get older, they make great trustees as long as you trust them and they get along. I would much rather have an adult child who's responsible and all beneficiaries trust each other as a trustee than a corporate trustee or a private fiduciary. And then your healthcare directive is equally important, and that's also something you want to keep your eye on and make sure that it's current with your wishes and that the people listed are also who you want. So yeah, I'm not saying you have to buy this insurance. I just know a lot of people make the comment that they never use it. So if you have the insurance, I would encourage you to get the value of it. You're paying for it. Call ARAG, get your case assist numbers, put an estate plan in place. It's better to have one so that you can make all these decisions. And if you're a homeowner, you do want to have a trust to avoid probate. If you have younger kids, beneficiaries, having a trust is better because you avoid that outright distribution at the age of 18. So, and if you have an estate plan and if you haven't reviewed it in a while, or if you forget what it says, use your ARAG. I mean, it's kind of a use it or lose it. If you don't use it, those hours don't carry over into the next year. They're just gone. So it's always better to take the time, use your insurance, sit down with a good attorney, ask those questions, make sure you understand the answers, and just stay on top of everything. So when you take the time to have an estate plan, it's so much easier to have everything's in trust and avoid probate. Probate's not the worst thing, but it's not that great of an experience, and it's super slow and it's super expensive, and everything about your loved ones is part of that public record. And because you can avoid probate and save all that money by avoiding it, it's just better to avoid it. And it's so much better for you to pick who you want to be your advocate for financial and medical decisions. If you don't have these documents in place, then you have to go through a conservatorship process. And that's also public and expensive. And the courts pick who the people are versus you getting to pick who those people are. So I would definitely encourage all of you to be in charge of your own destiny, have your documents in place. You're never too young. Once you're 18, you should have an estate plan because you need durable powers of attorney. If you have children, you want these wills in place that have guardians named to raise your minor children. And if you own a house, you want to avoid probate. If you have little kids, you don't want them inheriting it at age 18. So for all these different reasons, just having an estate plan is worth its weight in gold, in my opinion. So thank you all so much for your time. I hope that you found this presentation informative, and I will get that handout sent over to Vanya and she can forward it to all of you. So unless there's any other questions, I think we got most of the chat. Anything on the chat that I didn't cover, please send me an email directly and I will be happy to answer any questions you guys have. Okay, well, have a great rest of your day. Thank you.
Thank you so much, Heidi. Wonderful presentation.
Thank you. All right, bye-bye.
Gosh, she just rattles it all off.
I know. She's